Turn now to the state of Ohio in the case that's pending against defendant Lisa Nacrelli. So this lady is alleged to have impersonated a child services agent to lure a boy away from his home. And now she's set to stand trial starting on Monday. For more of the background of this case, here's Court TV anchor Julia Janae.
Every night he says his prayers and he just thanks God for catching the bad lady that could have taken him away.
Caught on security camera June 17th of 2023, 45-year-old Lisa Nacrelli approaches a 4-year-old playing in front of his house. Nacrelli speaks with the young boy, rubbing his head and asking him multiple times to come home with her.
Creeps us out a little bit. It's gut-wrenching.
Your intention was clearly to take my son, to convince him to walk down the street with you to this house, which I didn't even know you lived this close.
The boy's father, Timothy Spradlin, told police his son became uncomfortable, saying he wanted to go get his mom.
He's like, Mommy, there's some lady here that wants to talk to you.
I'm from CPS.
Lisa claimed to be with Child Protective Services, saying she was responding to a report made about the children in the home. She then entered the house, supposedly inspecting the property.
She shows me a badge that says her name. She proceeds to rattle off my children's names. She said I have to make sure that the children are safe for this home.
After Nacrelli left, the Spradlins contacted the Norwood police. Officers confirmed Nacrelli did not work with CPS. They arrested her the following day. In a statement, Nacrelli claimed she had been drinking all day and saw the child on her way to Kroger to get more beer. She says she wanted to scare the parents for leaving their child unattended.
I do find that she's a danger to the community, and I do believe the bond set is too low.
Nacrelli is charged with child enticement, impersonating an officer, and burglary. She has pleaded not guilty, but if convicted, she could face a sentence of up to 12 years in prison.
Oh, there's so much to say about this lady, isn't there? I have two outstanding guests in the studio to help me unpack this case. I want to welcome them in now. Magistrate, judge, criminal defense attorney, and former prosecutor Kimberly Bando is here, and retired deputy inspector for the NYPD, also the author of the book, Once a Cop, Corey Pegues is here as well. Great to have you both. Wow. And guess what? I have both of our wonderful guests here for the next 2 hours. So this is going to be great having you both when we go into the Karen Reed hearing in a little while in Boston. But we've got to unpack what's going on with this lady in Ohio, Lisa Nacrelli. She had this big hearing yesterday, and we're going to show it to you. So she's going to trial on this, despite the video, despite the witness testimony, you know, all of it. She's going to trial. I'm just kind of baffled at what the defense might be. Judge Kimberly, you are a practicing criminal defense attorney in the private sector in Atlanta. Talk to me, what might we expect to see from her team?
The only thing that I can see, either one, she needs to file a motion for a mental health evaluation. Like, what are we doing here? Who does that? And or maybe once upon a time she was went to social worker school, and that's what she's gonna try to lay her hat on.
Right.
Like there definitely has to be something else if she's going to trial, and she has attorneys, unless they are she's completely forcing their hand, because ultimately she has the decision and the power to make. I want to go to trial.
Right. Yeah, it's like you have to think maybe there's something mentally going on there, right? Like, who does this to a child? And the badge, she comes with a badge, Corey, you know, this fake badge. And so it's like she doesn't run away. When the kid runs away, she doubles down. She waits and says to the parents, can I come in? Can I look around? Flashes the... What does that make you think as a law enforcement officer?
Yeah, well, if my memory serves me correctly, when you look at her background, she has a checkered past. I think she has a mental checkered past also, and I think drugs. So there's obviously something going on with her. The defense attorney's only gonna do what the client tell them to do. I can't see these defense attorneys with this video sitting here for the world to watch to take it to trial.
Yeah, that video is bad, isn't it? Judge Kimberly, you were a prosecutor. When you see that, isn't that like gold for your case? And tell me kind of how you might use that trying this. Would you put in the open as well?
Yeah, I mean, it's like it's almost I would be scared because I'm like, am I missing something? Like, why am I trying this case? Why hasn't she taken a plea? And so I'd be scared because it's so easy to, like, you were there, you're on video, there's the badge, you're guilty of impersonation. What are we doing here? And so that's exactly what you would tell the jury. Like, she's guilty, here's the video, believe your eyes.
I love it. There it is. It's so creepy how she's like stroking his head, you know, and the kid's 4. I mean, and what a smart little kid. Oh my gosh, how I would love to meet this little boy. How smart he was that he knew, I got to get away from this lady. This lady is trouble. Corey, you know, I love asking you for safety tips. I do it all the time. One of my mother's favorite segments to this day was when you did a safety segment. And so here, when you think about what parents can tell their little kids, so this little boy's 4, some thoughts on what parents, you know, wonderful parents at home watching us right now can learn from this.
Well, the first thing they can learn from this is don't let your 4-year-old child go out. When you look at this video, what was really spooky to me is it's just a small sidewalk and the street is right there. That's numero uno. Numero 0 is you should be with your 4-year-old child. You know, my daughter is 11 years old, and sometimes she wants to go walk 2 blocks to the store, and I'm like, no, it's not happening. I'm just letting my 16-year-old walk to the store. So, you know, you have to really have your eyes on your children at all times. I mean, I don't let my kids go anywhere. If they're not in eyesight, they're not going anywhere. But, I mean, you know, you live in these different towns. But remember this, Julie, that lady lived down the block, Judge.
Oh,
she lived right down the block.
Yes, she did.
So I want to know, like, what was she doing? Was she scouting the kid out? You know, was this her first time? She's like rubbing him like she was very comfortable with him. And then I want to know, are the parents letting the kid out all the time? So.
Yeah.
But none of that has to do with what she did. She's wrong.
Yeah, oh, most definitely. And it does go to premeditation. I love that you mentioned that, and we'll talk more about it. We have to hit our first break in the show. So here's what we're going to play when we get back. We're going to get you up to speed on this motion to dismiss. So her attorneys, you've heard our conversation, our take on this. What's yours? Her attorneys are saying, Judge, throw the whole case out. It doesn't have any merit. Yeah, we're going to play it for you next. We'll talk about it on the other side. My 2 best friends were just murdered.
An all-new Court TV special.
We have found 2 bodies, double homicide investigation.
The arrest of Richard M. Allen of Delphi.
Child murder!
Everyone's first reaction was, who?
No criminal history.
They got the wrong guy.
Hiding in plain sight.
He's either the unluckiest guy in the world, or he was there.
The Delphi Murders, the case against Richard Allen, premieres Sunday, 8/7 Central, only on Court TV.
She shows me a badge that says her name. She said I have to make sure that the children are safe for this home.
Welcome back to Court TV Live. We've got defendant Lisa Nacrelli allegedly trying to lure a 4-year-old boy away from his home and then impersonating a CPS worker when his mother came outside. And now she's getting ready for her trial on Monday. You got to hear this, my friends. Her attorneys were in court on Wednesday and they argued to the judge that her case should be dismissed. Take a look.
Basic premise of this argument is that the state employee that's contemplated under the 2925.51 statute needs to have, by statutory authority, a duty to conserve the peace or to enforce all or certain laws imposed by statute, and on top of that, the authority to arrest violators. Now, if we look at just, for example, the full title of the statute that we're contemplating today: impersonating a peace officer, private police officer, investigator of the Bureau of Criminal Identification and Investigation, or federal law enforcement officer. Now, in researching this statute and the previous case law that's been litigated in numerous courts in Ohio, the main recurring theme in every single case is that every single charge brought under this statute is to do with someone impersonating a police officer, a security guard, a private security guard, or a sheriff. I have a stat here of the case law. While they don't pertain necessarily to this argument, every single person that's been charged under this statute has a duty to enforce all the laws and the statutory right to arrest violators of breaking the law. And the argument in this case, and the reason that we filed the motion to dismiss, is because as the statute and as the indictment alleges, Ms. Nacrelli is alleged to have impersonated a CPS worker in this case. And CPS employees and workers, one, there's going to be a different argument maybe throughout whether or not they're state employees, but they certainly do not have the authority through statute to enforce the laws or any type of authority to arrest any violators of the laws of Ohio.
If it was just people who could arrest others or enforce the law, then why would the legislature put "or employee of the state"?
Well, Judge, I think if you look at the legislative intent behind this statute, as I said, the title of it all lists people who have the authority to arrest individuals. The legislative intent of the statute is to encompass everyone who can, by law, enforce the laws, and therefore it follows on that they can arrest violators of the law. Now, while there's a small sprinkling in the D and E part of this statute about state employees, the only part of this statute that addresses the definition of state employees addresses it specifically the fact that they have to have, by statute, the authority to enforce the laws and have the authority to arrest violators of the law. So there's nothing in the statute itself, in the plain reading of the statute, in the A part of the 2921.51A, it lists all the definitions of the people who fall under the purview of this statute. It goes through peace officers, federal officers, everything. It defines everything. And the only time it mentions a state employee in the statute, it explicitly states that state employee has to have, I keep repeating myself on the part about the arresting authority and the authority to enforce laws. So we would argue that the state employee definition as it pertains to this statute, the plain reading of this statute that we have in front of us today and that Ms. Nacrelli is charged under, that the state employee has to have that investiture from the statutory authority and the authority to arrest individuals. We can't, we just have to look at the plain reading of the statute itself, and that is what we have, and those are the definitions that we're, bound to follow. So, as it pertains to how Ms. Nacrelli is charged as a allegedly impersonating a CPS worker by statute cannot do any of those things. Therefore, she does not fall under the purview of this statute, because I believe what the state of Ohio is alleging is that when Ms. Nacrelli entered the habitation, she entered to commit a felony offense, and that felony offense is the impersonation of a peace officer. But if that impersonation of a peace officer doesn't cover what Ms. Nacrelli was doing that morning, there's no underlying offense to the burglary charge.
Could it, well, I understand. So even if I agreed with you as to count 2, the impersonation of a peace officer or a private police officer as under the statute, even if I agreed with you to dismiss that count, the burglary, the elements of burglary aren't necessarily intertwined in that if there is another animus once inside of the house, right?
If there was, and if there is, correct, but there is not.
Well, that's what has to be proven at trial, correct?
If there is something else if there's another theory the state is moving forward with, then, that would be news to me. But as far as I'm aware, they are moving forward with the underlying offense for the burglary being the impersonation of a peace officer.
I see. And not the underlying offense, or the underlying offense being the attempted abduction?
I would be very surprised if that's what the state are moving forward to trial with. But if Ms. Polson can shine some light on that, that would be, eye-opening for me. But I do not believe that is what they're moving forward with, seeing the evidence and seeing the timeline of events that took place that day.
Oh, I always say, don't get mad at the defense attorneys. They're just doing their job. When we come back, we're going to hear the state's response as prosecutors argue that motion is inappropriate. Stay tuned. We have some major breaking news to share with you now as New York's highest court has overturned Harvey Weinstein's 2020 rape conviction. A New York appeals court ruled that the judge in the landmark Me Too case prejudiced the former movie mogul with improper rulings, including a decision to let women testify who weren't part of the case. So what does this mean for Weinstein? Well, he's currently serving a 23-year-long sentence on the New York convictions, but he'll remain in custody since he's been convicted in the rape case in California. So he's been sentenced to do 16 years on that. But what this means is that the court has ordered Weinstein to get a new trial. So this could mean that all of his accusers on that indictment could have to relive all of that trauma all over again if the state decides to retry him. This is a stunning ruling based on what we call, and we know here at Court TV, as prior bad act evidence. Some of those witnesses were not part of the indictment, but their stories and their testimony were allowed in for limited purposes, motive, opportunity, absence of mistake, things like that. And Weinstein's conviction has stood for 4 years. 4 years, and now it's been overturned today. So this is a stunning turn of events and certainly a setback for everyone in the Me Too movement who had advocated so strongly to get justice for everybody who had been wronged and abused and sexually assaulted by Harvey Weinstein. So we'll let you know if we hear anything from the district attorney's office. It's going to be their call if they want to move forward again. But as it stands right now, Harvey Weinstein's rape conviction has been overturned and a new trial has been ordered by New York's highest court. Let's turn back now to Wednesday's motions hearing for defendant Lisa Nacrelli in Ohio. The 45-year-old looking at multiple charges, and prosecutors say she tried to lure a 4-year-old boy from his front yard last June. Bad news for her defense team. The alleged abduction attempt was all caught on Ring doorbell video. Before we went to break, we saw the defense team asking the judge to kick the case. Now, listen to the state's response.
The primary position of the state is that the Ohio Rules of Criminal Procedure do not allow for summary judgment. And essentially, the motion to dismiss is a motion for summary judgment on the 2 counts. And that is not an appropriate motion under the Ohio Rules of Criminal Procedure. Presumably, the defense is raising this motion under Criminal Rule 12, although they don't mention that in their motion. However, it's Criminal Rule 12 is that prior to trial, a party may raise by motion any defense, objection, evidentiary issue, or request that is capable of determination without trial of the general issue. Here, the court cannot decide this without trying the general issue in the case. And furthermore,
the general issue being
what happened that day. So the court is not able to decide without making factual determinations about what happened that day. Ohio Jobs and Family Services is a state agency administered at the county level. So when a Jobs and Family Services worker is, going out and interviewing families and investigating claims and doing all of these things on behalf of the people of the state of Ohio, and they are working for the state of Ohio at the county administration level. So they would certainly fall under agent or employee of the state. And I would note, Judge, that in my motion for judicial notice, I would note that there is a case, We Child Care Center, Inc. versus Ohio Department of Jobs and Family Services, that recognizes that JFS workers are state employees.
what case is that? I don't see it in the...
It's in the footnote on my motion for the court to take judicial notice.
Oh, yes, I see.
Yeah, it's in the footnote.
Thank you.
Would you like me to read the cite into the record?
Yes, please.
We Care Child Center, Inc. versus Ohio Department of Jobs and Family Services. 2014-Ohio-2913.
Thank you.
So, in the present case, the defendant, I think you will find when the when the case goes to trial and you hear the state's case, that the defendant holds herself out as someone with CPS. And she only does this, I'm starting to get into my defense of count 1 as well, Judge, if that's all right with the court.
All right.
She only does this after the child in the video says, I'm going to go talk to my mom. Her attempt to get away or cover her tracks from trying to talk to the child, take the child, is to pretend to be a CPS worker. So I think that that's important when you consider count 1, because even if the court is inclined to dismiss count 2, in count 1, when she pretends to be a CPS worker, she's really trying to cover her tracks from talking to the child. And she tours that house. She goes as far as to tour the family's home and comment on the cleanliness of it, in covering her tracks from trying to take that child.
So it's the state's theory that the underlying offense in the burglary, once in the house, is both or either?
I think it's both and either, or either, yes. I mean, I think that this is one course of criminal conduct, and there are multiple crimes being committed here, you know, from the burglary to the attempted abduction to the impersonating a CPS worker. I mean, they're really all intertwined. So I think it could be either. And frankly, I think it is both, where she is, the reason that she pretends to be a CPS worker is not for the fun of it. She's trying to cover her tracks from her inappropriate conversation with this child.
All right. Thank you.
And even if the court decides to dismiss count 1 and 2, then the courts could still, or excuse me, even if the court decides to dismiss count 2 and you do not believe that that's part of the attempted abduction, the court could still find the defendant guilty of the lesser included trespass and habitation on count 2, which is the felony 4. So in the language of that statute is, no person by force, stealth, or deception shall trespass in a permanent or temporary habitation of any person when another person other than the accomplice is likely to be present.
But according to your argument, there has to be evidence presented first to even make that decision.
Oh yes, that's absolutely true. There must be, I mean, frankly, I think that the most appropriate ruling here is to deny the motion because it's not the appropriate time to be presented to the court. But there is no motion to dismiss on criminal counts. That's a Rule 29.
All right. Thank you very much.
Okay. Thank you, Judge.
Okay, so now we've heard the arguments from both sides. Let's listen to how the judge rules.
I would have loved to have some evidence today on this motion. Some evidence about JFS workers. They can tell us if they're state employees or not. Perhaps that's going to come at the trial. But to do it today, to make the decision today, when the court really doesn't have any evidence as to whether or not they're county workers or they're state employees, kind of puts the court in a position to make a decision blind. I think is premature. So what I'm going to do is I'm not going to decide the case until I hear some evidence on the issue.
All right, the judge reserving ruling on this one. They're going to trial on Monday. So I guess she's going to take it step by step. Was that the right ruling? Well, let's bring in our resident expert judge, Judge Kimberly Bando, on the show today, along with law enforcement expert Corey Pingees. Judge Kimberly, your thoughts on what the judge did here?
Yeah, absolutely. I would know if she didn't want to grant it, but she didn't have a reason not to. So it's like, I'm going to wait. I need to have more evidence, just like she said, before I can make an informative ruling on this issue. So it sounds like they're going to trial. Because, I mean, the only way you're going to get the evidence is because you had the hearing, you didn't have it. They didn't give her what she needed, basically. So they're going to trial.
Right.
And then you can re-raise it.
At trial, yes, put it in as part of the trial record, right, Judge? And so that's going to be important, you know, of course, for the defense primarily. And yeah, I know that she changed lawyers because the first lawyer had said that Lisa Nacrelli wanted to waive her right to a jury trial and go judge on this case. And, you know, of course, I was like, you know, pick 12, Corey Pegues, and then she changed her mind, got new counsel, and they said, we retract that waiver. We want a jury trial to hear this. Smart move for her?
Yes, because all you need is one juror to give some reasonable doubt, and because the judge is locked in.
Oh, yeah.
All into the law. She knows everything, you know her. You guys know everything. Women, you know everything. So, I always take my chances with a jury if I was going to trial, definitely.
Oh, yeah. I mean, you know, and we have an expression in the courthouse, okay, in our courties at home, especially those of you abroad. Shout out to all of you watching in the United Kingdom and all of the places around the world where you watch. You know, we always say, if you're innocent, you go judge. If you're guilty, you go jury. So think about that, you know, and because if you have Judge Kimberly Bando hearing your case, you know she's going to see right through the nonsense if you bring it. All right, when we come back, we're going to get an update for you on how this child victim is holding up. Remember, this little boy's 4. That was a stunning incident. That was something that understandably shook him up. Thank goodness he had the wherewithal to go to his mother. And his mom talked to Court TV after Wednesday's hearing. So we'll hear what she had to say next.
We are underway in the trial of doomsday prophet Chad Daybell.
Prosecutors say they will seek the death penalty against him.
Investigators have recovered human remains at Chad Daybell's residence.
There's no way, Morgan. I can never come up with this.
His wife, Lori Vallow Daybell, has already been convicted.
Now, will her husband end up with the same fate?
It's just so hard to know where the truth ends.
It's the doomsday prophet, Chad Daybell, on trial.
Welcome back to Court TV Live. I'm Julie Grant. So at the heart of the case against Lisa Nacrelli is a 4-year-old child victim who prosecutors believe was just moments away from an abduction. After Wednesday's hearing, the child's mother spoke about how the family has adjusted since their encounter with Nacrelli. Take a look.
How's your son doing?
He's doing better. We've got him into counseling, and he's doing better. He's still hit or miss on things, but we're working on it.
All because of what happened?
Yeah. Oh, yeah. He's very hesitant to talk to anybody. I mean, he doesn't, like, he won't even say hi half the time, you know, just casually, just, you know, you walk down the street. Oh, hi, just trying to be courteous. He won't even do that. He's like, nope, I don't talk to strangers at all.
Is that different than what he was before the
Before he was, yeah, because we always like, you know, walk around and have a good time and, you know, just be very courteous and friendly, and it's okay to be friendly, just, you know, whatever. Yeah. But he won't even do that anymore. He's like, don't even look at me because I don't know who you are.
Really?
Yeah.
And
which is fair. Which is fair, and I'm not mad at it. That's right. Don't even say hi.
Yeah, right. So your husband's doing all right, everybody's doing all right, and just getting back, and you just want this thing to get underway?
I just want it to be over and know that we're going to get the conviction that we want. That's really what I want. I need it to be over with.
And you've never seen Lisa Nacrelli before, right?
Never a day in my life before this incident.
All right. Take us back to that day. What was that like for you? Well, you were in a rush, for one. You were going to a swim party, right?
Yeah. No, I just got back from a swim party.
But you were going somewhere else?
We were going out to my my sister's house, yeah, for a graduation party.
Tell us how proud you are of your little boy.
I'm very proud of him. Very proud.
For what he did?
Yeah.
He finally, what did he do? Tell him, put his hands up, what he did.
Put his hands up. He said, I got to go talk to my mom. I'm proud of him. These are proud tears. because it really lets you know that that what you tell them is it sinks in. You don't know if they're listening, but it did. It sunk in. He listened even though he was 4. He knew what was right from wrong. So.
And is that the whole stranger danger message that Tim was talking about before?
Oh, yeah.
On him?
Yep.
Yeah. If you had a chance to sit in the room with Lisa Nacrelli, what would you say to her?
I honestly,
anything you would ask her, anything you would say to her?
if I was to just have one-on-one time with her, I probably would start with words, but I don't feel like it would end that way, just to be honest. I might ask her a few questions, but I've pretty much come to my conclusion of where her brainwaves are at, so.
Because she duped you as well.
Oh, for sure.
If there's any criticism at all on your side of the family, it's why did you let her in the house?
Because she presented herself as someone that either you're going to let me in or the cops are going to show up and let me in, so might as well just do this the easy way.
You know, she could potentially take your child away?
Oh, yeah. Oh, yeah. She was very clear that she was there because there was a implication that there was something going wrong in my home and that my children were in danger. That is exactly what she said to me. I have to make sure that your children are safe in this home. Exactly what she said to me.
Good thing for your security camera?
Good thing for that. Now I've got 5 more set up, so.
Go through the day that this happened, when you found out what was going on, what was happening. Talk about what you felt and how you reacted.
Like when I found out that she really wasn't from CPS, is what you're getting at?
Just no, when you realized something was amiss.
Amiss.
When your son.
My heart literally hit the floor. Yeah, when this all started, it was very stressful anyway. But I just was going with the motions, okay, this is what you're supposed to do, that I've heard. I don't know, I've never been in this situation. So, and then when it's going through, I was very confused the whole time, like, really, why are you here? I don't understand. I've never even had a single complaint about anything, but okay, just do what they say, is what I've always been told. You just do what they say.
Because you were tending to your other child, right, at the time?
Yeah, my baby. Yeah, I was changing his diaper at the time. So, it was just a few seconds to me. Yeah. And then when it all came to fruition and I found out, the truth, I can't even really explain between rage, sadness, everything, and concern. And I still live in that threatened stage. I'm always on edge at my house, even when we're out and about, but definitely at home. I'm always looking up and down the streets, and because really mindset is, okay, well, yeah, she's locked up for right now, but really, what was her full intentions? And is she working with anybody else? That's really what so I'm constantly thinking, well, if she's working with somebody else and nobody's even thought about that side, who's going to come up to the door next?
All right, what'd you think of Mom there? And what do you think of the fact that Mom wasn't outside with her little boy, who's 4, at the time that this occurred? Let's talk about that with our guests. Judge Kimberly Bando and law enforcement expert Corey Pegues are on the show with us. Corey, we were talking a little bit about this off camera. So tell us what you're thinking when you see that the child's 4, totally alone at the time. How fortunate was he that something didn't progress to the point of no return here?
Very fortunate, going throughout my career, dealing with missing children. It's so many missing children that's really not missing. And, we do this whole big thing trying to go and find a child. Every day, police officers, people are calling my child is missing. We usually end up finding them. But those times when we can't find the child, it's a big to-do, going to the house, looking in closets, looking in cars in the driveway, popping the trunks, looking through the dryers and the washing machines, lifting them up. So your heart is raised. This is a big to-do, but I think the reporter missed a question there, because my question would have been to her, have you let that child out the house by himself again? I would love to see if she's still letting that child out of the house. She wasn't too convincing to me. I mean,
Right.
So to all the people out there know, children are one of our most precious jewels.
Yeah, they
you
sure
have to hold them close. No matter if you live in Boise, Idaho, where it's a lot of space, or New York City, where it's, you know, everybody's
Crowded,
on top of each
yeah.
other. You have to watch your children.
That's the truth, Corey. Yeah, you're right. You know, it's the child who deserves all the credit here, right, Judge? I mean, the mom, you know, the mom wasn't there. The child was the one who thought, I'm getting out of this situation. Your thoughts, please.
Yeah, I mean, even her, and what her own words actually started triggering my mind when she was like, was she working with someone else? And so then I went to sex trafficking. Like, and she wasn't, like, what if she really was a sex trafficker, not just a mentally ill, drunk, whatever the case may be? Then this would be a different case. Like, your child would be gone. Because if it was actually a sex trafficker and she was, he would be in a white van by now.
Exactly. Oh, that's such a great point. And I'm glad you brought up the intoxication, Judge, because we looked up at 2005, she had a disorderly conduct, public intox. 2011, disorderly conduct, public intox. Apparently, she had made statements that she was drinking that morning of this incident. Corey, I know you remembered intoxication. You did with her. Is that going to fly, though, in court? We know intox, not a defense, Judge, right? Legally, do you think the jury would have any sympathy for that?
Absolutely not.
Nah.
They're not going to have any sympathy. Because even with 2005, 2011, you had these intoxications. Did you get any help? And then now we're 10 years later, and you're still drinking? You didn't learn your point. You know,
Yeah, exactly. She had a lot of time to get help. That's the truth. Monday, this lady's going to trial. We're going to follow it on Court TV Live.